This is Bob Marshall. I was a state legislator for 26 years in Virginia, and I worked in Congress for 6 years for one Democrat member and two Republicans. I'm going to explain to you the illicit process that is being used right now, largely by Democrats with maybe two or three Republicans, to resurrect the dead Equal Rights Amendment using only 3 states to ratify this proposed amendment to the Constitution, which passed Congress in 1972 but failed of receiving 38 states, as well as what would happen even if an Equal Rights Amendment were passed legitimately, again out of Congress and receiving the approval of 38 states. First of all, what are the operative words of the Equal Rights Amendment? Simply speaking, they state, equality of rights under law shall not be denied or abridged on account of sex. Sounds simple. It's very complex and deep with meaning and serious radical consequences. First of all, the 1972 Equal Rights Amendment, if revived, would require the drafting of women, if men are drafted, and fighting in frontline ground combat, even if there were not a draft. The ERA would require tax-paid abortions, no abortion restrictions for all 9 months of pregnancy, and penalize doctors and nurses who are opposed to abortion by yanking their medical licenses. The ERA would end women's and girls' privacy rights in homeless shelters, prisons, hospitals, locker rooms, gyms. Also, if you board a plane right now, TSA inspectors are female to inspect females or to frisk them, but males would be able to do that. Matter of fact, you could not prevent males from frisking females as you board a plane. Men and boys could demand to play on women's and girls' sports teams and effectively ruin high school girls' efforts to gain scholarships. The ERA would add tax exemptions for religious schools and churches with male-only clergy. Now, the ERA lost for certain in 1982 when only 35 states ratified it. In fact, the original deadline was 1979, and the ERA proponents secured an unprecedented 39-month and a few days extension. The extension was needed because ERA leaders clearly knew their efforts were failing. For example, Eleanor Smeal, president of the National Organization for Women, told a congressional committee in the House of Representatives, quote, "We are currently in a state of emergency on the ERA. We believe the life of the Equal Rights Amendment is indeed in peril, so we implore you to not close the door on constitutional equality for women, and that you vote to extend the time limit." Congressman Harold Volkmer was on the Judiciary Committee. He asked the question of Representative Barbara Jordan, an ERA proponent. Volkmer also was an ERA proponent, but he had problems with extending it, not using a 2/3 vote. Anyway, he asked Congresswoman Jordan, in the event we did not extend by March 22nd, 1979, do you have an opinion as to whether Congress could open it up again for ratification? Representative Barbara Jordan, Democrat from Texas, a black woman, congresswoman, she said, Congressman Volkmer, the time will have expired for that resolution, and I do not feel that it would be a viable issue for consideration by Congress because the resolution would for all intents and purposes be dead. Well, despite ERA proponents claiming that Congress could fix a deadline in the late 1970s, they claim that it's not possible to fix a deadline. That, of course, is wrong. In fact, the U.S. Supreme Court ruled that Congress may impose a time limit to ratify amendments. And that case was Dillon versus Gloss in 1921. And the court said, of the power of Congress to fix a definite period for ratification, we entertain no doubt. Moreover, the Supreme Court and Congress clearly affirmed that state legislatures have no authority to ratify the ERA after June 30, 1982. June 30 was the last date for ratification under the 39-month extension. October 20th, 1978, Congress passed House Joint Resolution 638, purporting to add 39 months and several days to the ERA ratification period. The resolution's wording is very precise. Said the ERA, quote, shall be part of the Constitution when ratified by the legislatures of 3/4 of the several states not later than June 30, 1982. They didn't say through June 30, 1982 or after June 30, 1982. June 30 was the deadline. Further, the clerk of the U.S. Supreme Court on October 4th, 1982, notified Lawrence Tribe, who was counsel to the National Organization for Women, that all pending lawsuits associated with the extension of the ERA were moot because 3/4 of the states had not ratified it. Next, Jimmy Carter himself was told by his own Justice Department that the ERA could not be revived if the ratification time expired. His legal counsel, John Harmon, Assistant Attorney General in the Justice Department, wrote to Carter and said, certainly, if a time limit has expired before an intervening Congress has taken action to extend that limit, a strong argument could be made that the only constitutional means of reviving a proposed amendment would be to propose the amendment anew by 2/3 vote of each House. Harmon also told President Carter, who's a Democrat, that comments on the floor of the House and Senate generally assume that the 7-year period was a limitation on the time in which ratification could occur. Now, let me get into some of the more specific consequences on this. The ERA will require women to be drafted if men are and fight in frontline combats whether or not there is a draft. Now, the first quote I have is from Senator Sam Ervin. He was a Democrat from North Carolina. He was very prominent in the Watergate hearings, which ended up with the resignation of President Nixon. He said in debate, quote, "The position of the Justice Department and the Defense Department is that women will be subject to the draft," end quote. Right now, all men, when they turn 18, are supposed to sign with the Selective Service in case there's a need to draft men for a war. If the ERA passed, women will also be required to sign the Selective Service. Failure to sign up for Selective Service right now means you will have problems getting a driver's license. You won't get certain grants from the state where you reside. There's all kinds of social consequences, legal consequences as well. Moreover, the brain trust for the Equal Rights Amendment, Yale law professor Thomas Emerson, and some colleagues wrote as follows: "The Equal Rights Amendment will have a substantial and pervasive impact upon military practices and institutions." Listen to this. He said, "The amendment permits no exceptions for the military. Neither the right to privacy nor any unique physical characteristics justifies different treatment of the sexes with respect to voluntary or involuntary services. These changes will have a radical restructuring of the military's view of women. A woman will register for the draft at age 18 as a man does now." Now, Emerson was an advocate of the ERA. This is even more interesting. Ruth Bader Ginsburg, who was then a law professor and is now a member of the United States Supreme Court, stated, "Equal rights and responsibilities for men and women implies that women must be subject to draft registration if men are. Supporters of the equal rights principle firmly reject draft or combat exceptions for women, as Congress did when it refused to qualify the Equal Rights Amendment by incorporating any military service exemptions." Now, that's from a book called Sex Bias in the U.S. Code, in which Ruth Bader Ginsburg was one of the authors. What she's talking about is an attempt to amend the Equal Rights Amendment to reserve for Congress the ability to exempt women from the draft or frontline ground combat. They were offered in the House and the Senate. Both lost to still give Congress the authority to make such an exemption. This is from a Congressman Dennis who was opposed to the ERA. He said the proponents of the proposed amendment all concede that if this amendment is written into the U.S. Constitution of the United States, Congress will be compelled at any time it drafts men for military service to draft women, and any time it drafts fathers to draft mothers. The drafting of American women and mothers into the military service would go far indeed to transform us into a National Socialist state. National Socialist state was Nazi Germany. And this is from Paul Freund, who was a Harvard law professor, opponent of the ERA. He said, "Actually, as I have read the debates, the proponents are quite literal and, for example, acknowledge very freely that women would be subject to compulsory military service. The next consequence of the ERA would require tax-paid abortions, force doctors and nurses to perform abortions or lose their medical licenses, allow sex selection abortions, actually prohibit a ban on sex selection abortions, ban any abortion restrictions, whether informed consent, waiting period, clinic regulations for all 9 months of pregnancy." Now, this is a statement from Congressman Henry Hyde, who was the author of the Hyde Amendment, cutting off Medicaid-funded abortions. That amendment passed in 1976. He's talking to United States Senate subcommittee here in 1984. And he said, "Since 1970, ERA advocates have emphasized that the amendment's principal legal effect would be to make sex a suspect classification under the Constitution." He goes on to explain, "If sex discrimination were treated like race discrimination, government refusal to fund abortions would be treated like a refusal to fund medical procedures that affect members of minority races. Suppose that the federal government provided funding for procedures designed to treat most diseases, but enacted a special exclusion for sickle cell anemia, which affects only black people. The courts would certainly declare that exclusion unconstitutional. Mr. Hyde goes on to state conscience clauses which give doctors and nurses in state-supported institutions the right to refuse to participate in abortions would be treated like laws giving state officials the right to deny services to blacks but not to whites. Now, clearly those are unconstitutional to use race as a criteria. But remember, Congressman Hyde is saying that sex would become a forbidden classification, as is race right now. The next consequence would be that the ERA would end privacy rights for women and girls doing TSA or police pat-downs, and in locker rooms, changing areas, prisons, hospitals, and women-only homeless shelters. This is from Professor Paul Freud. The strict model of racial equality, moreover, would require that there be no segregation of the sexes in prisons, reform schools, public restrooms, and other public facilities. It has been stated that equal treatment would not be required if it ran counter to prevailing standards. That's what some of the ERA proponents were saying, but they were just pretending that would become an effect. Freud says that is an escape valve not found in the amendment itself and one of very uncertain dimensions. At this point, ERA people knew they were getting in a deficit with losing votes for ratification, so they made up stories about what it would not do, which did not comport with the actual meaning of the words. Senator Sam Ervin said, this is in congressional debate, police practices by which a search involving the removal of clothing will be able to be performed by members of either sex without regard to the sex of the one to be searched. Segregation by sex in sleeping quarters or prisons or similar public institutions would be outlawed. This means that if some young women in college are out having too much to drink one night and they're arrested, taken in by the sheriff to the local jail, they will be put in a cell with males who may be accused of rape or sexual assault. And they will have to be put in such prison cells because making a distinction by sex would be outlawed. Now, let me quote a constitutional scholar very prominent in Virginia, A.E. Dick Howard. He wrote a 2-volume commentary on the Virginia Constitution. He said, segregated institutions would violate the ERA. Segregation of institutions on the basis of sex harkens back to segregation based on race. As with race, separate but equal sexually segregated institutions would not be allowed. Regulations must be designed to protect both sexes, for instance, protection from heterosexual or homosexual assaults. Therefore, the simple segregating of the sexes for sleeping or bathing purposes would be insufficient and would be discrimination in the guise of protection. And let me quote Ruth Bader Ginsburg again. She said, prisoners could be assigned to institutions based on the nature of the offense committed, disciplinary record, danger of escape, and other security considerations. But she says, gender should not be a relevant factor in determining institutional assignments. That was, again, from Sex Bias in the U.S. Code. She said that when she was a law professor, and now she is a prominent member of the U.S. Supreme Court. In Anchorage, Alaska, right now as I speak to you, the Hope Women's Shelter, which consists of one room with mattresses set 3 to 5 feet apart, is under attack by the city of Anchorage, Alaska, for violating its regulations. This is primarily a women's shelter, although they help men in the daytime, but Anchorage's Equal Rights Commission is investigating the Hope Center for allegedly violating a local ordinance after a biological man sought overnight housing, and the Hope Center referred the man elsewhere and paid for his transportation to a hospital because he was injured and inebriated. With this investigation, Anchorage is trying to force the Hope Center to house biological men alongside women in a shared overnight sleeping facility. Now, this is just the ordinance of one city. This will be the policy nationwide. And all these women's shelters, which have battered, abused women, sexually assaulted women, will have to accept men with backgrounds that include sexual assault. If they don't, you'll be violating the so-called Equal Rights Amendment. The next consequence of the ERA would that it would end female sports, including chances for scholarships as we now know it. Massachusetts has had a state ERA in their constitution very similar to the one proposed in 1972 for the federal government. I'm referencing here an article from ESPN, which is not a religious organization at all, but it's a sports media conglomerate. The Massachusetts Constitution says you cannot make a distinction based on sex, according to Roger Dowd, the governing body's longtime attorney. This is a Massachusetts Sports Association. Before the Supreme Judicial Court, Dowd argued that allowing boys on girls' teams would put girls at a disadvantage. A former Olympic gold medal swimmer Nancy Hogshead McCarr maintains that the Massachusetts court got the case wrong, created a mixed-gender competition situation that is unique among U.S. states. She pointed out other states also have an Equal Rights Amendment, but they don't look at it for sport. So the wording of an Equal Rights Amendment and how it is applied in court with what level of meaning, such as strict scrutiny where there's no exception, brings on these adverse consequences. She said the reason this is wrong, she was an advocate for the Women's Sports Federation, is that because girls will lose opportunities. In other words, boys will take the scholarships away from girls in high school, which is not fair. And ESPN noted, this article is from 2012, in the 2010 Western Massachusetts Division Title I game, South Hadley forward Ben Maynard scored the winning goal, colliding at full speed with Long Meadow goaltender Corey Hedges, a young woman, who suffered a concussion on the play. In Connecticut, for about the past 18 months, boys claiming to be female have won several track and field contests, edging out girls who would have otherwise won. The 1972 ERA would ensure that transgender girls, meaning biological boys, could not be excluded from competing against girls. The Alliance Defending Freedom litigation organization in June 2019 filed a lawsuit with the U.S. Department of Education Office of Civil Rights on behalf of 3 female high school athletes who must now compete against boys claiming to be girls and who have posted faster track times in competition. The suit claims the 3 girl athletes from Connecticut and others are losing their opportunities for recruitment and scholarships, and they're now being directly and negatively impacted by a new policy that is permitting boys who were male in every biological and physiological respect, including unaltered male hormone levels and musculature, to compete in girls' athletic competitions if they claim a female gender identity. This discriminatory policy, Alliance Defending Freedom states, is now regularly resulting in boys displacing girls in competitive track events in Connecticut, excluding specific and identifiable girls, including complainants from honors and opportunities to compete at higher levels and public recognition critical to college recruiting and college scholarship opportunities that should go to these girls. As a result, in scholastic track competition in Connecticut under this scheme, more boys than girls are experiencing victory and gaining advantages that follow, even though postseason competition is nominally designed to ensure that equal numbers of boys and girls advance to higher levels of competition in their respective sports. The suit was filed because the complainants are maintaining that it violates Title IX's mandate of equal opportunity for both sexes. The next consequence is that religious groups and single-sex private schools would lose tax-exempt status. In testimony from Jeremy Rabkin before a 1984 Senate subcommittee discussing the 1972 Equal Rights Amendment, which was reintroduced after it lost in 1982, was reintroduced in 1983 and considered in 1984. Professor Rabkin states, "It is indisputable that the Equal Rights Amendment would prohibit direct federal, or for that matter, direct state grants to any single-sex institution. It is very, very likely that the Equal Rights Amendment would prohibit tax exemptions for single-sex institutions, and indeed tax exemptions for institutions that practice any form of sexual differentiation. What are they? Catholic seminaries, which exclude women for the priesthood, would be ineligible for tax exemption. Orthodox Jewish schools, which maintains separation in seating between men and women in religious ceremonies, would also, by the same reason, be ineligible for tax exemption. Contribution to the schools would also not be tax deductible." Professor Rabkin also notes, even participation in federal student loan programs would have to be forfeited by schools that made some kind of sexual distinction. In January 1975, before a Missouri State Committee hearing the then pending 1972 ERA, a senator asked the lawyer for the ERA proponents if the ERA would deprive single-sex private and religious schools and colleges of their tax exemption. She readily agreed and added that the proponents want this because they object to tax exemption for any school or college that discriminates on the basis of sex in its admission policies. Some ERA proponents claim that women are not full persons under the Constitution. This is completely false. Harvard professor Paul Freund noted in testimony to the United States Senate subcommittee, quote, "The Supreme Court has not held, as is sometimes loosely stated, that women are not persons within meanings of that amendment." He was talking about the 14th Amendment. Then there's this myth going around from ERA proponents that Justice Scalia, conservative justice, somehow said the 14th Amendment didn't protect women. Well, these people are not quoting the entire record. I found an interview with Nina Totenberg of National Public Radio with Justice Scalia. She mentioned in the interview, Totenberg, covering women under the 14th Amendment? Scalia said, well, come on, covering women under the 14th Amendment. He laughed then. Women were always covered under the 14th Amendment. What are you talking about? Were they entitled to due process of law? Could you send them to jail without a trial, without a jury? Come on, women were always covered by the 14th, Totenberg said. Scalia didn't mention it, but of course discrimination against women in employment and other spheres is now banned under federal law, a ban that Scalia has consistently enforced. Now, I know in Congress it's mostly hard left. Actually, there are no moderate Democrats left in Congress. It's mostly Democrats who are pushing this. But Democrats were not always so radical. In fact, Democrat Presidents John F. Kennedy and Lyndon Johnson from the 1960s both opposed the Equal Rights Amendment. President Kennedy had a commission on the status of women, which discussed this and held hearings on the Equal Rights Amendment and women's status under federal law. The commission's report stated, quote, since the commission is convinced that the U.S. Constitution now embodies equality of rights for men and women, we conclude that a constitutional amendment need not now be sought in order to establish that principle. In 1968, President Johnson's Interdepartmental Committee on the Status of Women issued a report called American Women 1963 to 68. And like President Kennedy's commission, they did not recommend support for the passage of an Equal Rights Amendment. Let me go back and mention something about President Kennedy's commission. They studied this for 2 years. And its Committee on Civil and Political Rights held open hearings on the question, something that President Nixon's commission did not do. President Nixon's commission, a Republican, did support the Equal Rights Amendment. But a critic of it, a Myra Wolfgang, who was vice president of the Hotel and Restaurant Employees and Bartenders International Union, told a Senate Judiciary Subcommittee that Nixon's commission was unrepresentative in composition, and it held a different concept of the purpose of government, and because they are totally unaware of what real working women and housewives of America really want. That was from her testimony in 1970 for a United States Senate subcommittee. The last point in this introduction on the ERA is that the ERA will require identical treatment of men and women, not equal treatment. There is a big difference. Now, this is from a Congresswoman, Bella Abzug, who gave testimony in 1971. I was working up in Congress for a Democrat around that time. He was from Minnesota. She said the amendment itself, that is the ERA, quote, would wipe the slate clean, would eliminate all present legal distinctions based on sex, and would reject the presumption that sex is ever a reasonable legal classification. Just think about that. You couldn't use sex in any public sphere or public policy aspect. Now, let me quote you Professor Philip Kurlan, who was of the University of Chicago Law School, who told a Senate subcommittee in 1970. He stated, it is suggested that the proposed amendment, that's the ERA, seeks not equality of the two sexes before the law, but identity of them. And surely the elimination of differences between men and women cannot be obliterated by constitutional fiat. And so far as I know, the current state of knowledge of the biological sciences is not yet adequate to bring about this as a fact. I guess he said this way before Mr. Castro, the Democrat running for president, announced at a Democrat presidential debate that basically men can get pregnant. Now, let me quote you from an Assistant Attorney General, William Rehnquist, who later became the Chief Justice of the United States Supreme Court. This is in hearings that he mentioned this to the House of Representatives Judiciary Committee. He said the ERA's broad language would add substantial uncertainties in this area of constitutional law, which would probably require extensive and protracted litigation to dispel. He also added, we would have some doubt as to whether there is a national consensus for compelling all levels of government to treat men and women across the board as if they were identical human beings. If these things concern you and you want to do something, please consider purchasing my book called Reclaiming the Republic, published by Tan Books. It's on Amazon, or you can go to Tan Books in North Carolina. Thank you very much. I will be addressing other aspects of the Equal Rights Amendment in further podcasts.